As you said, the guideline was based originally on a statutory scheme and on directives, specific directives by Congress at a time in which more serious child pornography offenders were identified based on the volume, based on the number of photographs that they received in the mail. And that made total sense before, when we didn't have the internet, when we didn't have distribution. But the way that the guideline is now structured, based on that set of circumstances, is leading to extreme disparities in the system. Courts are adjusting their sentences in order to account for the changed circumstances.
That sounds like defending child porn, guys. But hey, what do I know? I'm just a community college guy. Mike Davis. Joining me now, Mike Davis. He's the founder and president of the Article 3 Project, former law clerk for Gorsuch, I might add. Mike, all right, look, I'm just a humble community college guy, but that sure sounds like someone who wants to be on the Supreme Court is defending giving light sentences to people who traffic in child porn.
That is 100% true, and this has been a 25-year pet project for Ketanji Brown Jackson, going back to her Harvard Law School days, when she wrote a published note in the Harvard Law Review arguing that sex offender registries are unconstitutionally punitive. When she served on the United States Sentencing Commission from 2010 to 2014, the Sentencing Commission, their job is to recommend sentencing ranges to Congress and federal prosecutors for the various crimes. She took it on her own initiative as a commissioner. Usually it's you're doing incoming. What does Congress or what does the Attorney General or what do other judges want us to look at? On her own initiative in 2012, she made child pornography. These cases make up less than 2% of the federal docket, but she made providing lighter sentences to people who possess and distribute child pornography one of her issues. And then when she became a district court judge in D.C., a federal district court judge for 8 years, out of the 7 cases that we could find where she had discretion on these child porn cases, Judge Jackson sentenced these predators to sentences below what the guidelines recommended and what the prosecutors recommended. So this is not a one-off thing. This is a 25-year pattern as evidenced by her public record.
Okay, Mike, maybe this is the wrong question to ask a lawman, but I can't help but ask it. That's so bizarre. Everyone hears the words child porn. I didn't want to say it on the show, and they want to vomit in the trash can and throw the book at somebody. That's a bizarre cause for someone to take up. Do you have any idea why?
That needs to be asked of Judge Jackson at this hearing, but I'll tell you, her position is she thinks that there are people who, so child porn is child rape. These kids cannot consent. So we need to remember this is child rape. And there are people who rape the kids, and there are people who watch other people raping the kids. And she thinks the people who are watching it should not be penalized as harshly as we do now, which is 5 years in prison for people who possess and distribute child pornography.
Good. Okay. Apparently, those sickos aren't the only ones she loves. She's got a history also with Gitmo. Can you talk about that?
Yeah. So she was a federal public defender in D.C. for many years, and it's her job to take on the worst of the worst cases: murderers, rapists, terrorists, whatever. So she represented Gitmo detainees during that time. I would say that she sought them out, but even so, that's her job as a federal defender. When she left the federal defender's office and went to a private law firm, Morrison and Forrester, MoFo, in Washington, D.C. I was at law firms for a long time, and you have limited time in private practice to take on free legal matters. One of her issues that she took on at MoFo is she provided her Harvard Law School credential, her Supreme Court clerkship credential, to advocate for habeas rights for Gitmo detainees, right? And she did this, and after her advocacy all the way to the Supreme Court of the United States, Justice Kennedy joined the 4 liberals and took her position that these terrorists have habeas rights. Since this time, 729 have been released from Gitmo. 229 have returned to terrorist activities, and 12 have killed 6 Americans. So Judge Jackson's 2 pet projects are child predators and terrorists who kill Americans.